All right, everyone, welcome back. We are here with Ted Ashton. Ted is the attorney that we turn to at Renaker Studio to keep us, out of trouble. He's one of the legal advisors at Airtail Financial and Legal Services, where he works with all types of small businesses. For me, you work with me as a designer and a freelancer, which I think will be relevant to the students, but also other entrepreneurs as well, and small businesses. And you kind of help them navigate some of the contracts of the world, and just you've got some good business advice. So I think that's a good reason for you to be here. Ted's the real deal. He's I think you're passionate about helping businesses and creatives protect themselves, their work, and their ideas. So thank you for being here with us today.
Yep, happy to be here. Thank you.
Awesome. Before I get into some of the goals of the panel, anything that you would like to state or introduce?
Well, a little bit just about my background. Law was a second career. Before I got into law, I was a business finance major, so I was always interested in business. And the first business that I actually ran was a film and photo productions company.
Go figure.
Yeah, right?
We have a lot of students that are in film and photo production,
yeah,
so they'll attach to that.
And a lot of people ask, well, how does a business finance major end up in film and photo productions? Well, my brother, graduating roughly the same time as I did, was studying film productions. And I said to him, I don't know what I want to do. Can you make a product? He said, yeah, I can make a product. I said, well, maybe I can market and sell it. And we went through this process of growing, building a contract, watching our contract develop over the years as we learned that a contract is not just legal protections, but it also outlines the relationship that we had with our client. It protects us from unique things that are occurring in that client-artist relationship. And so we learned, we grew a lot, and then after that I went back to law school and have always been passionate about the business community. I always knew that a large focus of my legal practice would be helping entrepreneurs, helping them grow, and I have a particular soft spot for the artist as I watched my brother really kind of try and develop a product that we became very proud of in the end. So.
Very nice. Thank you for being here. Some goals of today's panel. I just want to give each of you students sort of a legal primer on contracts, some of the rights that you have either as an employee or as a freelancer, but also, and perhaps a little bit more importantly, and I think Ted's going to like this word, your liabilities. We're going to cover some red flags and employment and freelance agreements, and maybe even just explain some of the ethical or legal gray areas through some examples that we'll walk through. All right, Ted, let's get started. What do you think designers should look for in a contract before signing it? It's a big question.
That's
to
a loaded.
start it off.
As I say, that's a loaded question. A few basics. Look, a contract is intended to outline the relationship between you and your employer, you and your client. It depends on A, what role you're assuming in the contract, and B, who you're contracting with. But obviously, in an art world, you want to make sure you understand the nature, the scope of the work that you're providing, the terms, compensation, make sure that that's clearly spelled out. And then one of the key factors in a art or employment related around art is who owns the rights to what you're creating. That's going to be different depending on the relationship that you have with the person that you're working for. Yeah. So those are some of the key things you're going to see. Yeah,
and those rights that who owns what, that typically stems around intellectual property. Is that correct?
Yeah. Who owns the rights to use that property and for what purpose? And maybe it's a shared rights around the nature of the work that you're doing. So
excellent, cool. Switching topics a little bit,
sure.
But still related to contracts. What is the difference between a non-compete and a non-disclosure agreement, and what do students need to know about both of them?
Okay, so a non-compete limits the nature of the work that you can do for others, okay? A non-compete, the intent is really to bind you to the person that you're working for. A non-solicitation, was that the other one?
Non-compete, non-disclosure.
Non-disclosure. Okay, sorry.
They're all sometimes
usually
together.
lumped together. But so the non-disclosure is essentially what you can and can't talk about. So to put it in an example, you're working for an employer. The employer says, we want you just to work for us. And after you've worked for us for a period of time, we want to make sure that the work that we've done together is not going to be provided to another employer. So that's going to be some of the basic terms in a non-compete.
Yep.
In a non-disclosure, it is essentially saying we want to make sure that the work that we're doing together is confidential, that the clients we have that work with us, the work that you're doing, is not being disclosed to somebody else. So, and a non-solicitation, since I mentioned it, is going to essentially say, you can't, after ending your relationship with us, you can't either solicit our employees to come and work for you or our clients to take the business. And usually those three things are going to come together in a well-executed, well-put-together non-comp agreement.
Yep. And those are, I don't know that I've ever had an employment situation, whether freelance or W-2 employment, that hasn't had that in its contract. So I think that that's important. Students know about that.
Yeah. And something to be aware of, whether you're the person drafting the contract or the person entering into the contract, a non-compete, what we were taught is the non-compete is highly disfavored in the law. The law does not want somebody to be restricted in the way they can provide their talents and their services to other people. So if you're ever in a position where you're an entrepreneur and you're trying to write a valid non-compete, it's critical that you work with somebody who understands the law in the area where you're working and can help draft something that will provide you the greatest protection without realistically infringing on someone else's rights to make a living. There's definitely a competing interests there, and it's important that you balance those.
Now, sometimes in a non-compete, speaking from experience when I was at PetSmart, you can have a non-compete that says you cannot go and work for these list of competitors for a certain amount of time, mostly because that company is worried about you transferring their IP to a particular competitor within a specific amount of time. Are there any other interesting sort of combinations of non-competes that you think students should just keep an eye out for?
So for a valid non-compete agreement, a court is going to be looking for something to be limited in jurisdiction and limited in time. When I say jurisdiction, geographical nature, and limited in the amount of time. And they're going to hold it to only the only what's necessary to protect the legitimate interests of the client who's the beneficiary of that non-compete. So if you're coming and you're working for me as a graphic design artist and I say, okay, for 20 years after you work for me, you can't do graphic design anywhere in the world. It's clearly going to be unenforceable. Right. But if, like your circumstance you mentioned with a prior employer, if it says, hey, look, for a period of 6 months, you can't go work for these 4 people who are directly in our industry, even that, I would say, could potentially be. It depends on the size of the employer. Again, if you're talking a global entity that could be anywhere, nobody who worked in Phoenix is going to be told you can't go work in Abu Dhabi for another company. It's just not going to work.
Yeah, so keep your options open.
Yeah, there you go. There you go.
All right, can employers claim ownership of your work?
100% they can.
All right, tell me more.
And in particular, if you're a W-2 employee, the presumption is going to be everything that you create for that employer belongs to the employer. If you're a 1099 or freelance provider, it is really going to depend on the nature of the contract. And the reason that is when you come and you work in a W-2 or employee-employer relationship, that employer is paying you for your knowledge, for your skills, and for everything you generate for them. And art is very much an asset. When we started Arete, we spent a lot of time back and forth creating a logo, creating a style guide that we felt we could brand around. And we're a small fry. You know, imagine Walmart, imagine Amazon, imagine Uber, some of these huge companies. Those people who came in and designed that are not going to be able to take that art somewhere else and just release it in a new arena. Now, in a 1099 arrangement, you may be able to say, hey, yes, I'm going to create this logo for you, but I'm going to maintain some rights to say I'm the creator of this information, and you may even be able to maintain the ownership of that. However, if you ever came and talked to me as a purchaser of art, I'm always going to advise, make sure that your contract says you own that art after.
Yep.
So that if you ever end up in a dispute with your artist, you're not stuck in a situation where now I've got to go rebrand, now I've got to go redraw my art. So think of your art as that's your product, right? That's what you're selling, and the buyer wants to own what they've purchased. You may want to, though, have some rights to say, call it just sheer bragging rights, marketing rights, whatever, and you can usually craft in a contract the ability to utilize the art that you've created and say, I made this, and take credit for the art itself while not necessarily still being the owner of the art.
You and I have worked on contracts in the past. We've called those portfolio display rights.
Right.
So I think that's great note there. What are a few things that a good freelance contract should include?
Sure. Well, aside from what we were just talking about, the portfolio display rights.
Yep.
It really goes back to, again, okay, I need to understand the terms, the scope of the work that we're going to provide. And in art, that's tricky, right?
Especially when one client from the next is vastly different.
Right. Well, is it an ongoing relationship? Are you my graphic designer? Are you my video editor? Are you my guy for a number of projects? Or is it a very specific task? As a lawyer,
retained.
Correct. As a lawyer, I have general business contracts where somebody retains me, and then they can simply call me and say, hey, Ted, I've got issue X, Y, and Z. Can you help me out? I say, absolutely. We've already got a contract in place. Shoot me over a few $1,000 and we'll get started. The majority of my clients, however, and I think this would be the way in the art world, the majority of your clients are going to say, I need this task done. I need an agreement. Or in the art world, I need you to come and create a 2-minute web video for me. Okay, great. So terms, scope, compensation. Be very, very, very clear on compensation. And then, again, the portfolio display rights is a great thing. Also, be very, very careful with jurisdiction. What do I mean by jurisdiction? If something goes wrong, where are we going to have this dispute? A lot of this work, we're a small world now. It used to be you sat down in your office, and the person who was retaining you probably lived within 5 to 10 miles of your office. Well, nowadays, you might have somebody who retains you from Australia, and they're going to put a contract in front of you that is going to say, and if we have to sue you, it's going to be in Australia. You may want to push back on that a little bit. And a lot of that can be done with a dispute resolution document. I hate litigation. I hate courts, which is odd to say as an attorney. But contract disputes, if you have to put that on in front of a jury, there is nothing that a jury cares less about than why you and X corporation aren't getting along. All they're thinking about is I'm missing work, my life is getting behind, and I'm getting paid. I think the current rate at the Maricopa County Superior Court is something like $27 a day. So that's your compensation. Almost buys lunch downtown.
Yep. Certainly less than minimum wage.
Yeah. No, it's part of the, I guess, obligation that comes along with living in the nation we live in.
Sure.
You can draft in a dispute resolution clause that essentially says we're not going to sue each other. We're going to give each other, in my world, what I usually recommend for my clients is 30 days direct negotiations, then mediation, and then we can do binding arbitration if you want to really simplify it. You can also, one thing that I see a lot of artists do is they minimize their damages. Yep. Okay, you can contract for minimized damages to the scope of what you're actually receiving.
And that doesn't necessarily mean paying for attorney's fees all the time, which you may or may not get.
Yeah, correct.
What does minimized damages mean?
Well, let's say we put into your contract, they've hired you, they're going to pay you $5,000 to do X, Y, or Z project. And you're going to say, in the case of a breach where we can't agree on the remedy, my maximum damages are going to be $5,000. Typically, under most circumstances, that's going to be upheld unless you've done something truly egregious, intentional misconduct. Those types of things usually allow them to get around some of those things. But if we just have a misunderstanding, usually you can limit the damages. So that's important. You know, if you're working on a commercial, right, and so you get hired to film a commercial for the Super Bowl and you don't turn it over in time, there's
some damages there.
There's going to be some significant damages there. Yep. And so properly drafting the terms can potentially provide some protection for you. And this is one thing I always tell a lot of my clients. I'm a small practice, and most of your companies are probably going to be small companies initially unless you're working for a much larger company. Well, if you're the owner of a small company and somebody who can afford to put on a Super Bowl ad comes and asks you for help, you have to ask yourself, what bargaining power do I have in this?
Am I functionally capable of doing this work?
Yeah, well, and not just functionally can I produce and provide the work, but if I'm bargaining with Walmart and I don't like Walmart's contract, do I have the ability to bring my lawyer in
Sounds
and
like you're a big
negotiate
ship in low
different
tide.
terms? So in a lot of cases, the best thing you can do when you're going to take on a contract, particularly a larger contract, at least go to your lawyer. Make sure you understand what you're signing yourself up for. You may not have enough bargaining power to position yourself more favorably in the contract, but you do need to understand what you're agreeing to. And then have the self-control and the ability to say no when you can't deliver. There is nothing worse than contracting yourself into something that you can't deliver on.
Absolutely.
That's when lawyers, I'm a transactional lawyer now, and that's when the litigating lawyers get on. They're far less pleasant than I am.
Yep. Yeah.
So.
No, I love it. Ted, you're not particularly an intellectual property lawyer, but give us the cliff notes about what our creative students need to know about intellectual property.
Okay. Yeah, I appreciate the disclaimer. I've been in and around intellectual property, and as a business transactional attorney, I have to know a little bit about it. I tell everybody enough to be dangerous.
Yep.
Intellectual property is essentially saying who owns this art. I created this thing, who owns it, who has the rights, and not just so much who owns it, but who can use it, right? It's critical to make sure that you've got some basic protections on the IP that you're working with. In the contract, what does that look like? That looks like, and we talked a little bit about it, that looks like who owns it when we're done. That looks like who can use it when we're done. Is this a licensing agreement or is this a purchase agreement? The difference really functionally there, a purchase agreement, I'm buying something from you, I own it, I can do anything I want with it, it's no longer yours. A licensing agreement is you saying, hey, I created this, I'm perfectly happy for you to use it, here's the terms on which you can use it, the scope to which you can use it, but you don't own it, it's still mine. And a lot of artists will work with licensing agreements as well, particularly musicians, right? Yep. You'll go out, a video, same thing. We'll create this one thing, this sound, this image, this that's going to be used everywhere. Yep. And this company has a right to use it, this company has a right to use it. They're all, but it's limited based on the licensing agreement. So you need to understand in the IP world, am I licensing it? Am I purchasing it? Am I selling it? And that will kind of dictate who owns the IP.
Yep. A lot of our students, particularly those in like photo or video, who maybe they go on to work for a big ad agency, or maybe they're freelancing ads themselves, they may choose to license those images if it's going into a big magazine. Maybe Vogue can use that image, but Harper's Bazaar can't. So,
well, there's whole realms online. I'm trying to remember some of the. Back in my days, was it Photo Stock?
Yep. Shutterstock,
Shutterstock, iPhoto, all these places where you can go and you can say, hey, that image is perfect for the ad that I'm creating. Yeah. What you're purchasing is a license. And typically, those are going to say, some of them are going to say, download it today for $5 and you can use it any way you want to in the world.
In perpetuity.
Exactly. You now potentially own it. You don't own the image, but you own a perpetual license to use it however you see fit. Yeah. There's others, and again, if you get a little bit more notoriety behind your name, you can actually give a restricted license where, hey, I have to come to you and I say, I'm going to use this image, I'm going to put it out in 100,000 brochures, I expect this to be the scope and this to be kind of the reach of that marketing campaign. And you get to say, okay, I will let you use it for that particular campaign and the cost is X. You see that a lot with actors. I don't know if anybody in this group is going into the acting world, where an actor will say, okay, what's the reach, what's the scope? Am I going on a billboard? Because it's the name, image, likeness, the NIL, everybody, any NCAA fans?
Yep.
If you're licensing your image, your talent, that's usually going to be restricted in how you can use it. You don't get to film somebody one time and then try to work that in
Yep.
100,000 times in the future.
Yeah, it takes time to build that sort of repertoire.
Correct.
Yeah, very nice. When should someone, and this is a loaded question, I think potentially biased a little bit, but I think it's important for students to know when to consider hiring a lawyer, especially as a student, because, I mean, let's face it, we don't all have endless pockets. Lawyers are expensive. When is the right time to start looking at, hey, I should have a lawyer look at this?
Well, the very self-serving answer is always.
Sure.
Professor Renneker, is that what I call you in
Yep.
this realm? Yep. Professor Renneker has my contact information. Call when you're ready.
Yep.
No, realistically, when I guess the big question is, what's the value of the contract? What are the potential downsides to the contract? What's my exposure? You used the word liability earlier in our conversation. What potential liability do I have if I enter into this contract? The greater the potential liability, the greater the value to you from an economic standpoint, or even from a future standpoint of, hey, I'm creating something that I'm going to be able to leverage in the future in my practice and whatever I do. The greater the value, the greater the exposure, the more likely you're going to want to consult with an attorney.
Yeah,
so,
absolutely.
And look, there are attorneys out there like myself who are very passionate about business and small business in particular. There's almost, I can't imagine anybody in this audience today, if they came and said, Ted, we're brand new out there. Can I come and spend 30 minutes with you? Sure, come and spend 30 minutes with me. I won't charge you. Just tell me you're poor and getting started, and I have a soft spot for that. I've been poor forever. It's kind of a self-vow. That's why I keep starting new businesses.
Yep.
But that said, when an attorney is going to do more than simply say, here's my thoughts, they're going to want a retainer. Why? Because once I give you legal advice, now I'm on the line.
Mm-hmm.
And if we don't have a contractual relationship, I don't have the protection and you don't have the protection.
Sure.
So
Yeah.
it's a long-winded way of saying, take a look at the value of the agreement, take a look at your exposure.
Yeah.
And the greater on either side, the more likely you'll want to consult with a professional.
Yeah, absolutely. And I think that's why we're having this conversation too. It doesn't mean that every time you're asked to sign on the dotted line, go talk to your lawyer.
Right.
But it is, hey, if something sounds fishy, chances are there's fish in the room.
Yeah. Well, and let's go back to the IP question a little bit in context here. Some lawyers will not give you a Word draft of their document. So who owns that contract? Mm-hmm. When you go and you talk to a lawyer, especially if, let's say, you're going to go into the freelancing world and you say, hey, I need some contracts that I can use between my clients. Is your lawyer giving you a one-off contract, or are they giving you something that's editable that you can use in the future? I like to give my clients a PDF and a Word version of every document I create. But I do tell them, if you're going to go and monkey around in the legal terms on this contract, please call me first, because the second you change anything in this document, I am not responsible for that change. Yeah. But I can create you a document that has all of the legal, the boilerplate. You become familiar with that term as you start working with lawyers. The boilerplate just means everything that needs to be there because it needs to be there. Okay, jurisdiction clauses, dispute clauses, those types of things that need to be there. But what's
don't go monkey around in there.
Don't mess around in there. It's there for a reason. But if you're doing a services contract, there's going to be significant overlap from one client to the next. So if you get a contract that's generic enough in the service section, well, then you can kind of start crafting in, here's the specific service we're going to do, but the terms that apply to that service can all be the same. So
very nice.
A good lawyer is going to try and look out for you. I always tell all my clients, I want you to come back. I do, but I don't want you to have to come back
that much.
Not that I don't love you.
Yeah.
You're trying to grow a business,
yep.
and I'm a business owner, and I respect that. So.
Very nice, and I know we appreciate that at the studio as well, so thank you. We touched on this briefly. Let's maybe go a little bit deeper. What is the difference between licensing and ownership of your creative work?
Okay, so let's go from the creative professional's perspective. You've created something. Somebody wants to either A, buy it from you, or B, use it. If they're going to buy it from you, that is a purchase agreement. That's a simple contract that says, hey, I created this. you're going to pay me this, and when we're done, it's yours. When you do that and you sell it, you have to remember, unless you've maintained the right to say, in a limited capacity, to utilize that for your own purposes, you can no longer display that art. It's not yours. Your name may be in the corner on the signature, but it's owned by this person or this entity that purchased it. That's a standard purchase contract. In a licensing agreement, it's the end user is wanting to use it. You're allowing them to use it for a specific purpose and a specific fee. Once they have utilized it for that purpose, ownership is typically maintained by the creator. So it really depends on the nature of the work that you're doing. If you're going to be a graphic designer, be ready to sell most of your work, because anybody buying that does not want a license for something that they're building a brand around. If you're going into music or acting or something like that, be ready to license most of your work because you're licensing you, right? Does that make sense?
Yeah, absolutely. Okay. I think that's perfect. And can a client or a company force a designer to remove work that they've done for that company or done for that client from their portfolio after it's been published?
Well, it'll depend on your contract.
Sure.
If you have not maintained any rights to utilize it for your own particular marketing purposes, then yes, because they own it, and you are now
portfolio display rights.
Portfolio display rights, yes. And if you're using it outside because once you've sold it, you need to get their permission to display it, and that's why if you're wanting to do that, drafting that directly into the agreement, negotiating to have that in the agreement it's important. Do it at that time, because if you're coming back later, you may end up buying back your own work.
Mm-hmm. I'm drilling in on these portfolio display rights so heavily because I myself have come to your office in consultation of, I really need to be able to show this work, but they own it.
Right.
And it's a difficult conversation to have when you have to sort of approach it from the back end. So yeah. I think that's good. And also our students are always worried about building their portfolio, so they have work to show and get hired.
That's exactly what you do. I'm in a similar world in the legal world. I can't go showing other people the contracts I've drafted for their clients. It's all confidential. It's all done. Yep. They kind of have to trust me a little bit. Yep. And it's one thing. I've been a lawyer X amount of time. Yeah, I can draft a contract. Yep. Art is very subjective, right? I like this person's art. I don't like this person's art. How do you show them that without showing them that? Right. And I will tell you again, going back to my history as a former owner of a video and photo productions company, every single contract that I drafted and that I put out with a company, a bride, an event host, whatever it happened to be, I told them, you own the rights. We're going to give you digital copies of everything. You can do anything you want with them, but I maintain the rights to use these for my portfolios. And we'd have a particular event come together, and we had this beautiful presentation that we gave them, and that sat in my office, and that's how I sold ourselves. But it was in my contract.
Yeah, absolutely. And I think that there's something in there because students may go on and they may work for a big company that does not want you to put their work in your portfolio. I've had that happen. Yeah. And so in that situation, what is the best thing for the student to say, like, I've done this work, but I can't show you this work?
So, this is not legal advice.
Yeah.
There's a lot that you can do. I mean, everybody keeps track of images that they've generated, and what you say to a particular client is in a one-on-one conversation. Cameron, I want to retain you to do this. And you say, look, I've worked for big companies such as X, Y, and Z. They probably can't restrict you from saying, I've worked for big companies such as X, Y, and Z, which to me lends an instant credibility. Oh, I know that company. I've utilized that company. But to say, I've done this or I've done that, a reasonably creative way to do that would be, if you maneuvered through their website and found yourself on this page and that page, that's work I might be particularly proud of. You know what I mean?
Yeah.
Working your way around it.
Sort of situation engineering.
Correct, correct. But you have to be very careful. And look, I understand why the big companies want that, because if you're out there saying, I'm a part of this, then maybe they pick up some liability for what
Perhaps you don't have a particularly polished image or whatever.
And maybe that's why you're no longer with them. Who knows how that, and keep in mind, you never want to burn any bridges. Most companies are pretty reasonable. The bigger they are, the more bureaucratic nonsense you're going to have to deal with.
Sure.
So just know, if you go and work for Google or Amazon, yeah, the art that you're creating is it's theirs.
And I think a lot of creative professionals, a lot of us pull the work that we do from a very deep place in us.
Yeah.
And so sometimes when you're told this work isn't yours, it's a little bit of a chip on the shoulder, but it's the nature of the work we do.
It is. It is. And just remember, work of any nature is a quid pro quo. You're giving them something, they're giving you something in return. And as an artist, what you're giving them is your time, your talent, but you are in fact actually creating a product for them, something physical, something tangible that they're going to incorporate into what they do, into their product. So ownership is really important. But I think most places, if you're upfront when you start, and in particular, if you remember to do certain things at the beginning of the relationship instead of at the end of the relationship. At the beginning of the relationship, and it's funny, I tell this to a lot of my clients who are doing partnership agreements and different things. I say, negotiate the difficult stuff while you like each other.
Mm-hmm.
At the end of a relationship, when maybe things ended amazingly, right? But usually, even when they end on a good term, the company's sad to see you leaving, or there's a parting. Don't try to negotiate at that point. Negotiate on the front end. These are things that are important to me. You want me to be here, and these are things that are going to be important to me when I leave. It's a little easier point to start the negotiation. You have a little more bargaining power.
That's a great point to make. What would you say about the client who's like, it's fine, you can trust us, we don't need a contract?
Don't. If it's not in writing, it's going to be fought over. Yeah. Now, in Arizona, a verbal contract is absolutely 100% legal. You and I can come to an agreement and we can say, this is what I agree. Here's the problem. In the future, we don't agree anymore. What did you say? Well, I think you said what you said, and I think I said what I said.
Who's right?
Who's right, right? That's where it gets a little messy. And in courts, we're going to have to look at, well, they call it course of dealing, course of interaction. We have to look at all this extrinsic information to see, does that intrinsically drive what each one of them is trying to say? You just end up in litigation. It's a mess.
Yep.
So
And,
get it in writing. Get it simple. And if somebody says, well, I mean, why do you need? Well, don't you trust me? It has nothing to do with trust. It has everything to do with, ensuring that both people's values are respected.
Absolutely. I'm going to cuss in a moment here, but there's a wonderful video on YouTube. Go look it up. It's by Mike Montero. It's called Fuck You, Pay Me. And he brings his lawyer in, just as I'm doing here, and very similar advice there.
Yeah.
So
Yeah.
very nice. What are some of the risks of doing unpaid pro bono work?
So look, everybody should give back in the communities they work. Everybody should find ways to serve. Everybody should find ways to benefit the community around them. I'm a firm believer in that. Just protect yourself if you're going to do something. If you're going in and somebody says, hey, we need this by this date, it's pro bono. Just, if you sign a contract, you're contractually bound and you're potentially liable for damages.
Yep.
Okay? If you come in and you say, I will do my best, but I can't make any guarantees, you're protecting yourself a little bit. But yeah, you can create, anytime you contract, you're potentially on the line for anything that could go wrong in that relationship.
So even though the work is being done for free and you're not making any money on it,
Yeah.
it's still important to have a contract.
Absolutely. Absolutely. Something that lays out the terms. And look, when your mom asks you to design her wedding card for your younger brother, don't ask her for a contract.
No.
But if the neighbor says, I need something like this, you don't need a 5-page contract, but maybe a simple written understanding. Here's what I'm doing. Just understand the relationship. Again, I'm going to go back to, when do I need a lawyer? Maybe we'll say this, when do I need a contract?
Yep.
Same kind of basic principles. What's the compensation involved? What's the potential exposure involved?
Yep.
The greater the compensation, the greater the exposure, the more likely you need a formal contract.
Yeah.
And pro bono, again, the compensation doesn't exist, but it is a potential liability. And usually when you're doing pro bono, what are you going to do with that? You're going to put it on your page. You're going to say, look how great I am. These are the nice people I'm helping out. And that's great. You are getting value. Yeah. And you receive value. Just in you feel good about yourself. The community likes that you're involved. So, but you do want to be protected.
And I think there's also a little bit of relationship management happening there too, kind of going back to like, don't write the contract at the end. Well, oftentimes in pro bono work, it can sort of, especially if that work happens repeatedly, it can quickly evolve into an expectation as opposed to a generous donation of my time and services.
Yeah. Anything that's more than what I'll call a one-off, you and I say, hey, Ted, I need you to help with this. Great, knocked it out, we're done. If it's going to be a recurring relationship, that would be another big cue. Yep. You need to get something in writing.
Yep, absolutely. Last question on the contracts and employment section, then we'll move into a little bit of ethics and intellectual property. What should you do if a client vanishes, ghosts you, and disappears without paying after you've delivered the full scope of the services outlined in the contract? I think this is sort of a mysterious section. What does collections look like?
Well, I mean, do you want to know what I tell most of my clients? I say, suck it up, buttercup.
Yep.
Move on. This is where we're going to talk about the economics of litigation. Yep. Okay. Client A owes you $1,000. I'm going to call Ted, and I'm going to have Ted go after him. And Ted's going to ask me for $2,000.
The math don't math.
This is what I'm saying. Look, you're not in business school, but I hope every one of you understands that's a bad deal. Okay, that is bad business to throw $2,000 to chase $1,000. You already know this money may be gone. If you spend one nickel chasing it down, you might just be one nickel poorer than if you go before. So please understand before you ever even consider collections or going after somebody for a bad debt. Number one, does it make business sense for me to chase this person down, or do I just walk away? Now, if you're a huge company and you're doing thousands and thousands of transactions, you cannot have a reputation for just letting things go, because then you have thousands and thousands of people taking advantage of you. Okay? If you're a small solopreneur, entrepreneur who's running a small shop, you're going to have people who don't pay you. It's like I tell everybody as an attorney, I am not a pro bono attorney, at least not on purpose. Have I done some pro bono work, meaning I let a bill go, I didn't chase them down, I cut my bill in half? All the time. It happens all the time. So please understand the economics of collections. Number two, and critical to understand, why do some people not pay you? Is it because they ran out of money? Or is it because maybe they don't think you delivered on your side of the agreement?
I always tell my students, overpromise, overdeliver.
Yes. So if you open that can of worms, sometimes, and if you're just parting ways because, hey, the relationship is dead, you're not paying me, you don't like the work I'm doing, get an email, get a voicemail, something recorded that says, we're both agreeing to terminate this arrangement and we're not going to go after you. We're waiving any rights that we have. Something simple, we're done, we're not going to seek to collect anything from each other. Okay, great. Relationship's over and everybody moves on. But if you go after somebody for a $1,000 bill and you sue them, I'm going to go the whole way, this is on principle, and they are going to countersue. Now, what happens when the countersuit is filed? You're stuck.
You're deep.
You can't get out of it. You can't say, well, this sucks now, I don't like it. You said I screwed up, I want out of this thing. Well, you can't get out of it because they have now alleged claims against you. You're stuck. And I have seen lots and lots of litigants who get a $10,000 dispute and they're $15,000 deep into litigation fees, and the other party has more money than they do, and the other party's not willing to let it go. Yep. You're stuck.
Yep.
And now maybe you're representing yourself because you can't afford to pay your attorneys.
And that's a whole nother conversation.
That's it goes back to one of our earlier principles. It's a bad idea. Don't do it.
Yeah. No, I think.
Sorry.
No, you're good. I think the movies paint a picture of sue anyone and everything will be either right or wrong.
Yeah. And there are realms. Again, if you have a good dispute agreement, it's going to require direct negotiations. It's going to require a mediation. But there's realms where you can go. If somebody owes you $500, go to small claims court. But every step you take, just remember, you're an artist. What do you sell? You have one asset that you can repeatedly sell, and it's your time. Yep. And when you're in a litigation, the time, the stress, everything that's involved in that, you're not creating art. I have a fairly, I'm not a very aggressive person in nature, which is
shocking.
I can be if I need to be, but I'm not going to chase $1,000. I'm not going to chase $2,000. I have a
just not
brother.
worth it.
Yeah, I have a brother who's a litigating attorney, and when I was doing litigation, we had a conversation one day, and we said, "How much money would somebody have to owe you before you would even think about starting a lawsuit?" And we both came up with about $50,000. Now, if I'm owed $40,000, that doesn't mean I'm just going to let it go.
No.
I might send a demand letter. I might chase it down. I might try to find, a couple different relevant.
Mob boss.
That's not legal advice either. But I might look at certain remedies, but I would really, really, really be hard pressed. And before I ever filed a lawsuit, I would really be thinking, one thing they teach us as lawyers, you better understand the other side. You better understand what claims they're going to make, what arguments they're going to make. In a breach of contract scenario, don't be proud.
Yeah.
You are usually not the only credible opinion as to how things happen. A simple non-payment is usually one thing. If you delivered, if it met standards, if they've accepted it.
Yeah.
But let's say you delivered late. Maybe you didn't deliver a product they loved. Maybe it gets weird. So consider the economics of what you're looking into, and that's always a great question to ask a lawyer. I literally just had a client of mine send me an email. I fired them off a response. They were owed $1,300. And I said, for me to send a demand letter is $1,000. You already know you've lost $1,300.
If everything goes right, you're making $300.
Yeah. Best case scenario. Now, in my demand letter, I'll ask them to pay the $1,000, and they'll come back and they'll probably with an offer. Well, we'll pay $1,000 and call it a day. Which, what are you at? You're still out $1,300, and now you've gone through a lot of aggravation. I'm happy I made $1,000.
Yep. Very nice.
The only person who wins in a litigation every single time is the lawyer, and it doesn't matter if the lawyer's client wins or not because they get paid.
Yep.
So just be cautious with collections, and perhaps my colleague Bervelin's going to talk a little bit about that. Get paid up front.
Yeah.
And then you don't have to collect.
We'll talk with Berv a little bit about payment plans and.
It's easier to settle a dispute when you're the ones with the cash on hands. Okay,
There
it just is. You don't like the work? Fine, I'll give you some of your money back.
Which goes back to the contract and how the contract
Correct.
is set up in those payment terms. So,
Correct.
Very nice.
Get the money up front.
Yeah, lovely. Thank you, Ted. Let's shift subjects here a little bit. Getting into some ethical areas, and ethics by nature tend to be a little bit of a gray area. So, what happens if your work looks even just slightly too similar to another designer's or another company's something? So,
I mean, it kind of depends. Intellectual property, and again, the caveat, I'm not an intellectual property attorney, but I know enough to be dangerous.
Sure.
It's going to depend on the nature and the scope of how you're using something. Again, if you go out there and you create this logo and you think this is amazing, I'm working for a family with the last name Mann, and I'm going to create this golden M, and it's going to be amazing, and they sell hamburgers. Are you going to have a problem with that logo?
Most likely.
Yeah.
Depends on how the M looks.
Of course you are. Of course you are. Golden M selling hamburgers and French fries. Well, let's change it a little bit. Well, the Mann family runs a pig farm, and they're back, and the M is just a small part with McDonald. Get it, old McDonald? Sorry.
I see where you went.
You see where I went with that one?
Yep.
Good. You're probably okay. So it's not necessarily just how similar it is to another logo. And look, McDonald's logo of a big M. That's not unique. It's not different. So it's the way it's used, the color schemes, and the nature of the product that you're advertising.
And colors specifically can actually be trademarked.
Correct.
And all of that. So that gets a little deeper. But
red and gold, right?
Yep.
In M, you're not going to be able to sell hamburgers. That one's been taken.
Yep.
But blue and purple with an M, and what you're selling is office supplies, you're not going to have a problem.
As long as you're not selling tacos. Taco Bell.
Does McDonald's do tacos? Yeah, golden. There would be the bell.
I think that's the thing, is you got to be mindful not just of what is in the space you're working in, but also what's around that space you're working in.
Yeah, anytime you're doing art, you're doing design, it's very difficult to create something that is not going to have some amount of similarity, some amount of overlap with someone else's art.
Yep.
Unfortunately, art has been around for at least 20 years. Maybe a little longer.
A little longer.
A little bit, Renaissance, all those things.
Yeah.
So it's difficult to create something that's truly 100% unique. So you just have to understand that the law is not just looking at just the design, it's looking at colors, it's looking at organization, it's looking at the products that you're advertising and where you're advertising that.
Yeah. And there's not exactly a clean line between does this look similar or doesn't it? So
Yeah.
best just stay away.
Yeah, agreed. I mean, be cautious. Don't draw inspiration, but don't copy. That's not, that's copyright infringement. That's an IP violation. But again, if you create a logo for a carpet cleaner, a small carpet cleaner out of Tucson, Arizona, and it happens to look somewhat like a carpet cleaner in Des Moines, Iowa, it doesn't matter. It doesn't matter. There's no, the idea of intellectual property is we're trying to protect from confusion. We're trying to protect. But if you went to the same Des Moines, Iowa location, created the exact same article from a successful, and it was just a tad different, it creates confusion amongst the clients. And you are literally, what are you doing there? You're trying to take some of the benefit away from a brand and reputation that another company's built, and that's why it's illegal. That's why we allow for protection.
There's a really great analogy of that to Better Call Saul. He sets up a billboard right next to the law firm that he wants to work for, but wants to take the money away from. So I think that's that's a good analogy there. What are we talked a little bit earlier about like stock photo sites, things like that. What are the risks of using photos, maybe not that you found on one of those stock sites, but just on the internet?
The right click, right click
exactly.
copy.
Copy, paste, save.
Yeah. Look, if you are determined to have used somebody else's art, you are subject to a lawsuit. It's period, end of story. The question is going to be, what are their damages? What are and you might be able to find one of them coming and saying, let's say you right-click, you copy, it's an up-and-coming photographer, 10 years later they become very popular, they realize you're still using one of the other right-click copies from there earlier, and you've been using it in a marketing scheme, and now you're a multi-million-dollar company. Can that person come to you and say, I want a percentage of your revenues all the way back? Sure, I'd take that case. I'd love to argue that. Am I going to win? I don't know, but I'm going to get something from you.
Yeah.
I'm going to get something from you. You just never know what you're taking. So don't right-click copy. Now, if you're doing an in-office presentation, PowerPoint, you're creating your deck, and it's going to be shown to 10 people in the office, I got several right-click copy dad jokes in my estate planning presentations.
I love it.
Just understand the scope, nature. If you're using it for your gain, you are potentially subject to a...
In other words, if you're selling it.
Yes. Or if it's part of a marketing piece that is intended to bring, the name, image, likeness type stuff, intended to bring business your direction.
It's on a piece of packaging that's going out into the world, and that packaging's being sold, and you haven't licensed that image.
Yeah.
And that's not to say, I think we're sort of talking in a small scale, but a lot of students may go on to work for very large companies where that copy, paste, save could be huge damages. And just because we're telling you now, litigating a case might be more expensive than it's worth, that doesn't mean that's everyone's stance on it.
No. I mean, if you get Amazon on you, then they need to throw $20 million at litigation. Wait a second. Amazon just earned another $20 million.
Yep.
So they don't care, right? Big companies, just be careful. Use common sense. There are so many resources out there where there's free resources that you can use for art and design. And
or
frankly,
even paid with a small fee.
Yeah, exactly. Stock images. You didn't come and do 4 years of schooling or however many years it took you to get through. I did the 5-year route. To steal other people's work. Now, borrow, receive inspiration from, license, and utilize as a portion of your work, all the time. But just the general rule of thumb, and this is the legal part of it, is you need to compensate people for what you use from their work. You would ask the same. You want people to compensate you for the work that you've done.
Yeah, and I think that a lot of students might look at, buying a license for a stock photo site, and they say, oh, wow, $500, that's pricey for me right now. And that is a justifiable position to be in. But look at the cost of what could happen.
The downside is pretty significant, And again, look, if you're freelancing and you need to purchase a $500 stock image, reach out to your client. Say, hey, we didn't discuss this, but I'd really like to use this image. I think this really pulls it together. It costs $500. And if they say no, well, move on.
Have them flip the bill.
Exactly. Exactly. Move to the next piece.
Addendum to contract.
Exactly.
Awesome. Can you legally use a font or a typeface that you download for free?
I mean, I guess it depends.
Sure.
You know, each one of those fonts that you download, there's a licensing agreement. You know that thing where you put, I accept the terms and conditions, it's 27 pages, and you didn't read the first 2 words? I do it all the time.
Yep.
Somewhere in there, it's going to say whether or not you can use this and what purposes you can use it for. All of your fonts that you're looking at on like Word, other software that you've purchased, yeah, you're being told if you utilize our software, Photoshop, Illustrator, those types of things, if you use our fonts, you're okay to use these and license these. But if you're looking for a unique creative font, you go out into the world and find it, just download it and use it. There's a good chance, same thing as with the stock image, there's a good chance that you're utilizing someone else's art without paying a fee, and you're subjecting yourself to a potential issue.
And I think that's an important note. Typography in itself is a very fickle matter. It is in itself a design. It is in itself a work of art. And someone has taken the painstaking time, just as you've taken the time to design your work, to design that typography. So I think it's, and pay attention to those licensing agreements.
The irony sitting right here on your table are 3 design books, each of which uses a different font. We've got some serifs, sans serifs, some bold. Each of those fonts is under license and used under license. And if it weren't, you've got some authors.
Ted did his homework on fonts. He used serif and sans serif there.
Back in the day.
Yeah, I like it.
Don't grill in on which is which.
Sure, yeah. Let's see. Particularly, we have quite a few photo video people, and I think that you can speak to this from your former life here. What might be some of the consequences of using music in a video project without a license?
Music is a big one, and these guys have a lot of money.
Yeah. We were talking about one of these just before we started filming.
So it was interesting, and I don't know, again, I'd have to look into this. I don't know what the current status of the law is. They used to have what they called the one copy law in music, where if you purchased a song, you could use that song in a compilation of something you did for yourself that was not for someone else. So the classic, I'm going to create a photo montage for my boyfriend and or girlfriend and or both, and I'm going to put some photos to it and put that song. And I purchased that song. I own the CD. There was some law that said that was okay. But the second you use it for A, multiple copies, B, sharing around, C, as a demo product or something like that, yeah, you're subjecting yourself to some pretty significant risk. There are the licensing agencies are so much easier to work with today than they were when I was doing this work 20 years ago. Most of your companies that are out there, I'll use the wedding industry for once. I mean, how many wedding videographers exist that are out there that are just slapping music over images? And then what do? They create a demo disc, they put it on their website. I am telling you, they're going to get a cease and desist at some point. And that will be very, very, very expensive because
there are people at the record label whose sole job is to send cease and desist letters.
Yep. Now, but there are licensing groups that you can be a part of, but that's difficult when you're that startup. You're like, I'm just going to get out there. But I don't know. You would want your art protected, and these artists do too.
Yeah.
So yeah, be really cautious, music in particular, because it's easy to track.
There's money there that you can't even fathom.
Yeah, they're doing okay.
Yeah, they're not hurting at all. Okay, sort of modern topic here that is perhaps without precedence, but if a design is AI generated, who owns the copyright?
I would say pending. I am not aware of any case law. Now, again, I'm not, this is not an area because I don't do the litigation but that's going to come down the pipeline, you know. Yeah. You go into your ChatGPT, Bard, your, what else, Gemini, and you say, hey, create me a image or a song or whatever.
Can do full videos now.
Yeah, absolutely. I mean, if you haven't messed with it, it's pretty amazing.
Yeah.
We have a guy in our office who went in and created a country song that hawks our products.
Oh,
it's hilarious. It's a lot of fun. Who owns that song? Gosh, I don't know. I would make the argument we do because we were the ones who created the prompt, and this is a free software, and there was no licensing agreement. Of course, I didn't read the 18 pages before I signed it, so maybe there is a licensing agreement.
Yeah.
Just be careful.
Yeah.
AI, I was just at a conference talking about how AI and technology are going to be affecting the legal industry. It's obviously currently affecting and will continue to affect your industry. And ultimately, I think the consensus that we came to in our industry, which I think will probably merit some discussion in yours, is AI is a great place to start gathering data, organizing thoughts, creating inspiration, and creating maybe a foundation that you build the final product on.
Yeah.
And if you can use a tool that takes the brainstorming process from 20 hours to 2, wouldn't you be interested? Of course you should. You absolutely should be.
Efficiency.
But if you just turn that product over that AI generated, yeah, there's going to be some discussion on that.
Yep.
There's going to be some additional licensing. Right now, there's so many AI tools that are out there that are just free, and that's where it gets a little interesting.
For what it's worth, Ted hasn't even read the syllabus. You basically just quoted my AI policy from the syllabus verbatim, so that was
We're good.
Great. Yeah.
We're in sync.
Yeah, I love it. All right, so tell me a little bit about what rights do you have if your design, we've talked a little bit about licensing agreements, who owns the work. What happens, what rights do you have if your design is used beyond its agreed upon scope?
So if the scope was clearly defined in the contract and the scope has clearly been breached, you have a right to make it stop.
Yep.
The mechanics of how you do that, we talked about the...
A little bit fussy.
We talked about the economics of litigation. We talked about some of those different things. So the mechanics of that are a little bit challenging. But you do have essentially a right to make a stop to it. And courts have created what they'll call injunctive relief, which is essentially pre-litigation, before the litigation really gets hot. If you can prove a few things, and I'm not going to get into the legal rules and whatnot, but if you can prove that, again, you're substantially likely to win a case, that the facts are clear, they've breached this, and then a court will likely put a stop to that fairly quickly.
Yeah.
But if the other party believes they're in the right, you can anticipate some protracted litigation, which, again, you have to ask yourself,
What is it worth?
what's the worth? Do the business decision. As a business owner, you're constantly going to be making business decisions, and as often as not, those decisions are going to lead you to move on.
Yeah.
Now, if it's Amazon, again, who's your client? How much are they using it? Yeah. And you authorized Amazon to use one image for one marketing campaign, and it was wildly successful. That's great for Amazon, maybe bad for you, should have negotiated for more money. But they then roll it out on the 2nd, the 3rd, the 4th, the 5th. Yeah, you're going to sue them, and you're going to win a lot of money. It's going to be great. And Amazon probably would pay you because they don't.
They're Amazon.
Yeah, they're Amazon.
They just made $20 million.
Wait again, there's 20 more. So yeah, just know who your clients are. But if you think there might be some reciprocal value in your product, you can draft that into the contract. That if we're willing to use, think about the term section of the contract. We're willing to allow this term to extend on the same terms or on renegotiated terms. The only thing that have to be renegotiated would be the price. Get creative depending on the scope. And as you work through and you're working with an attorney, they should be asking. That attorney their job is to ask you questions. Most of my clients leave after our first meeting with more questions than answers.
Yeah.
And it's because I've answered the 2 questions they've had, and I asked them 13 more that are going to be relevant or should be relevant or appear relevant to me, and I have to say, I don't know if this is relevant or not. I need you to tell me if it's relevant. You know your industry better than I do.
I've been a victim of the TED treatment.
Yeah, you're welcome. But yeah, just the better you work with that attorney, the better the relationship you have, the more questions you have. It may cost you a little bit more because attorneys, we sell one thing, again, it's our time. Yep. But a few more hours of time could potentially get you into a much better product.
Yeah, absolutely. What happens if you accidentally infringe on someone else's IP?
So something non-intentional, and I guess it's as lawyers, we're naturally untrusting individuals. So when somebody says, I accidentally did something, we rarely believe that. It's like my child coming to saying, I accidentally played more video game time than I was supposed to.
Accidentally took 2 cookies out of the cookie jar?
Yeah, exactly.
Yeah.
It was an accident. But a true accident, and this does happen. You hear it in music. I think we were talking before this where you're writing your song and this riff hits your mind. It's amazing, and you're working with it, and all of a sudden you said, oh, that's because Queen did it 30 years ago and it's been playing in my mind for the last 30 years. Yeah, you're in trouble.
Yeah.
You're in trouble. We had that conversation. So just be aware. Do your due diligence. But if it truly is accidental, you're probably going to get a cease and desist. You're going to say, my bad, and you're going to pull it
sorry,
down.
I'm an idiot.
Yeah, no. and most people accept my bad.
Yeah.
Right? It is a
You have to dig your heels in pretty hard to get the...
Yeah, while not a legal argument, my bad is generally acceptable for most true mistakes.
Yep.
And we make mistakes. Sure. But yeah, just be cautious.
Yeah, absolutely. This is a loaded question. What is the best way to protect yourself as a creative professional, whether you are working in the industry, freelancing? What's the best way to protect yourself?
So, I mean, that question, I'm going to give you an easy answer. If you are freelancing and you are working on your own and you're not working under cover of a proper entity, an LLC is the most common, stop. Stop immediately. If you were in my office, I would say it's time for my lines and bubbles conversation where I draw a very, very bad picture. It's not art, but I sign most of them. Where we say, look, we want to contain the liability that you're generating in your business within an entity. That's my circle. And then we want to create a layer of protection between your personal life and your business life. That's the line. So if you can visualize a bubble here, that's your LLC. We're going to do all our work in our LLC. We're going to contract through our LLC. Our revenues are going to come through our LLC. We're going to pay our expenses, our salaries, everything out of this LLC. And then we're going to put this wall between what that LLC does and my personal life. Step one. Always, always, always step one. Step two, proper insurance. They have errors and omissions insurance. They have all sorts of insurance. I mean, it would be interesting, and I'm not an insurance agent. I don't know. I'm sure the professor here could tell you a little bit better than I can what types of insurances may exist that would protect you in the work that you're doing.
He's giving me way more credit than I'm worth. I'll have to bring in another expert for that.
Yeah, if not, he can send me a note, and I'll send you over to some of our insurance professionals.
I'll send my emails to the insurance people in the industry, and we'll have another panel.
Yeah, there you go. That's not a bad idea. But, so proper entity formation, proper levels of insurance. If you're working in a W-2 capacity, you're just an employee for an employer, just don't be stupid.
Yeah.
Don't
you have
steal.
Very few
don't steal stuff. Don't punch your coworkers. You're protected because of the nature of their entity protection. But be careful of who you're working for. If you're working for Susan over here, and Susan has no entity, and you're just working for Susan, now there you may be subjecting yourself to greater risk. One of the nice things about being in the art world is you're not truck drivers. You're not construction workers. You're not doing something that creates inherent physical risks.
I don't know. The carpal tunnel says differently.
Yeah, occupational hazard,
yeah.
Right? But just pay attention to who you're working for, what protections they have in place for you, and if you're on your own, I think if you're going to start your own thing and you don't collaborate with a business attorney, you're jumping over
significant hurdle.
Yeah, you're jumping over dollars and if not $100 bills to save pennies.
Yeah, I like to say I don't go to a lawyer to collect money after it's been lost. I go to a lawyer to make me money.
Yeah, and to protect what you're going to be building.
Yep.
Right.
Yeah.
There's nothing worse than, as business owners, as humans, we create liability for ourselves. We just do. We're inherently human. We make mistakes. We have accidents. We do those different kinds of things. Properly protecting yourself just makes sense.
Yeah.
So.
Yeah. I have a feeling your answer to this question would be all of them. But what clauses should you never agree to without negotiation?
Compensation. I mean, that's an easy one. I would be very, very speculative about any non-comp. I don't like them. I don't think anybody should restrict your ability to be who you are. I feel very differently about non-disclosure, confidentiality type agreements. Yeah. Those I think I'm absolutely fine with, but telling somebody they can't do. If you're going to have a non-comp and they're going to limit what you can do with your skills, ask for more money.
Oh yeah.
You need more money.
And why is that important? Why is it important if they're asking you to limit where you can go to work? Why would you ask for more money?
They're taking an opportunity away from you.
Yeah.
It's the same thing in a legal capacity. If somebody asks me to do a huge job and it's going to restrict me from being able to work for 10 other clients, I'm going to ask for more money.
Yeah, because you're not able to go and make money from those other clients.
Opportunity cost, right?
Yep.
Back to Econ 101. With every choice I make, there's an opportunity cost. If I choose to participate in activity A, I cannot participate in activity B. Yep. And what they're telling you is not to choose A or B. They're telling you to choose A, and when A no longer works for you, you can't do B either. Well, then they need to pay you for A and B. So you negotiate for additional compensation or negotiate to get rid of that clause. I'd be very, very concerned about jurisdiction and venue clauses. Now, jurisdiction, venue, what do you mean? Go back to our example we talked about earlier. If you're doing work for a client who's out of state, out of country, they don't want to sue you here. They want to sue you there. Yep. And if you're not cautious about that and you just sign away, well, you might be finding yourself in Great Britain dealing with a lawsuit over 10 grand, which they know. What does that mean you're probably going to do? Yep. You're going to write them a check for 10 grand because you got to pay either that or you got to go to Europe and maybe it's worse.
And pay for your lawyer to fly to
exactly.
Europe, too.
Yeah.
And I think that's not even just true for international work, but I mean, a company, if you're working in New York, they can say, we're going to have jurisdiction in New York.
Correct.
And
within the United States, intrastate, even within the state. So jurisdiction and venue clauses, choice of law clauses, those are all couched down in your boilerplate that everybody just skips over, doesn't think is important until they're getting sued in New York.
Yep. With different laws.
Yeah, exactly, totally. You know, I'd have to kind of go through, I'm visually going through my contracts right now. Term, compensation for art professionals, ownership of property is, the nature of the agreement, licensing, purchase. And I mean, there's a whole bunch of others that become relevant to some degree or another. I tell everybody I've never put a clause in a contract that I didn't think had any value. But I put a lot of clauses in contracts that don't end up becoming relevant.
Valuable.
Under the circumstances.
Sure.
But I tell people if it were to have become relevant, you would have been really unhappy if it weren't there.
Yep.
So,
nice.
Yeah.
Very
Hopefully
nice.
that was helpful.
No, absolutely. Last question for ethics and IP, and then I've got a couple bonus questions here.
Bonus.
What can you legally showcase in your portfolio as far as your work goes? And better yet, when can you show work in your portfolio and when can't you?
I'll answer your question by restating the question.
Sure.
You can legally showcase anything that you can legally showcase.
Yeah.
So what does that mean? Well, what did your contract say?
Yeah.
Is there a non-disclosure in there? If there's a non-disclosure in there, then you probably can't showcase it. If in your contract and in your agreement there is a property usage right, then you can probably use that intellectual property. So it really, that's a difficult question without understanding the nature of the relationship that you had on any particular job. If you're a freelancer and you're doodling and you're drafting and these are conceptual drawings, all of that is your art. All of that can be put on display. The second you sell that to somebody else, if you do not maintain the right to use it, you don't own it anymore. Licensed documents, you can probably use it, but you have to be cautious of, hey, you can't, looking at the nature of the contract, one of the things that we all love to do is here's a list of people that I've worked for, right? If you've worked for large, recognizable names and brands, that lends credibility to you. If McDonald's can trust me as a lawyer, surely you, Bob's Burger, can trust me on your one burger stand. I know what I'm doing, right? But I can't, as a lawyer, disclose that I work for McDonald's unless McDonald's tells me I can. I don't work for McDonald's. But you know what I mean?
That would be a nice payday.
Right.
Terms and conditions.
I'm sure they're doing okay. As an artist, same thing. You probably are going to have some confidentiality in there, and you probably ought to be just out of mere respect for your client. Get their permission.
Yep.
If it's something that's important to you, put it in your contract. And if they're fundamentally opposed to it, they'll say, hey, can we scrub that? And then you have to decide, is it worth it or not? And if you say it's worth it, yeah, I'll scrub it, but what am I going to say as a lawyer? Get more money.
Yep.
You're giving them something, get additional compensation. I am willing to take this out or I'm willing to no longer display this sell it to you. But if I can't use it as my demonstrative work, I want an extra $1,000.
There you go.
And then they can decide how important it is to them. They might say, we like it, but we're not going to pay an extra $1,000. What's the harm? You can put it on your website.
There you go. Yeah. We may need you to write your bubbles and lines chart. We've got a little whiteboard over there. We might need you to do that later.
Perfect.
All right. Couple bonus questions here. What would you tell, we've touched a little bit on it, but what would you tell a student who might be looking to go into freelance work?
Okay. Ironic that you bring up bubbles and lines. That's the first step. The first step before you go out, before you even try to negotiate your first contract, before you do anything, form your entity. A properly formed entity in the state where you're going to be providing your services provides a level of protection that nothing else can do. It's not terribly expensive. It's not free. You can do it on your own, and then you can come to me and I'll fix it later.
That's speaking from experience.
Yeah,
that's what happened with us.
It's, why will an attorney do? Attorneys, we don't do anything for less than $5,000. It's just like I don't want to touch it.
Yep.
But why will we form an entity for $500 to $1,000? Well, because we want to get you in there. We want to build a relationship with you. Yep. We're anxious to showcase our skills, showcase our personality, and that we understand your business. We can empathize with you, and we can build that relationship. So you have somebody you can go back to as a bit of a counselor. That's why they call us counselor. Yep. As you move forward. So if you're going to start with the proper entity. Yeah. Number two, look, and this is just from experience, all legal aside, just understand what you're getting yourself into. Yep. When you work for somebody else, typically you have a job, you go, you do your job, you put it away, and you're done. When you work for yourself, you're always working. You're always working. And I've always, I shouldn't say always, but in 25 years of my professional life, I have been on my own for about 15 of them. Yeah. And they have been the most satisfying 15 years of my life. Professionally, and they have also been the most difficult. Yeah. Far more. When you work for somebody else, it's great. You go, you show up, they write you a check, and what do you do if they don't write you a check? You go, I'm not coming back here, and you go somewhere else, and they write you a check.
One of our earlier panelists said there's nothing more addicting than a consistent paycheck.
Yeah, they call it the golden handcuffs in the law. I'm sure you've heard that in other areas, where they pay you just enough that you don't go. Yeah. But there really is nothing more satisfying than getting out and doing this on your own. But make sure it's something you're passionate about. Yeah. Being an artist is not being a business person. Being a lawyer is not being a business person. Being a, we inherently can become very, very good at what we do, and doesn't necessarily transition to you're going to have a successful business, and that can be very aggravating. Yeah. But I've told a lot of people, when you start a business, there's a few people you need to build a relationship with. And this may sound a little bit self-serving, but I told this to people before I ever started the company I'm at, where we do the tax, accounting, financial planning, and business. I said the first person you're going to meet is your attorney. Then you're going to meet your insurance agent, and then you're going to meet your accountant and tax preparer. Okay? Those are some things, just don't do them on your own. Yeah. It's not terribly expensive. The smaller you are, the less you'll pay for those services, and you're going to build a relationship. A company like ours, we have a very symbiotic relationship with our clients. We don't want you not to succeed. Every business that fails that's a client of ours is a lost customer. Yep. We want to see you become fabulously successful. And whether it's our business or another one similar, whether you're working with a tax preparer, whether you're working with, those professionals are there for one reason and one reason only, to see you succeed. Yeah. So they offer value. But once you've built those relationships, the next one I always hope to introduce you to is our financial guy, because that means you're making money. Yep. And he's going to help you learn how to keep that money and grow that money. So those lawyer, insurance, tax and accounting, and then financial.
Absolutely. Okay. And I think what you said about making sure that the people you work with, the businesses that you work with, that they're successful, that's a business model. Yeah. If they're successful, you're more successful, because hopefully they want to come back and work with you. Right. When would you potentially hope to see, we've talked a little bit about set up your LLC. When would you hope to see a freelancer who's maybe just doing 1099 work set up an LLC and then similarly transition into an S Corp or C Corp?
So a freelancer who's doing 1099 work is already too late. You should have set it up before you started doing the 1099 work. going back to the beginning, you are doing a service for an entity and you're subjecting you, your personal life, everything to liability if you don't have that. So the point when you think, I am going to work for someone else outside of a relationship, an employee-employer relationship, W-2 income, that's when you should look at setting up the LLC. Now look, if somebody comes to you, you're a W-2 employee over here, and they say, hey, would you do this XYZ design job? Yeah, $500. Do you set up an LLC for that? I don't know, probably not. If that's happening to you every week, and you're doing a ton of side work, and you're making $10, $20, $30, $40, $50,000, yeah, set the LLC up. Give yourself the protection.
Yep. And the tax benefits.
Correct.
We'll talk about that with Bervelin.
Yeah,
in a
I was
little
going to
bit.
say, when you talk to Bervelin in a little bit, she's going to talk to you about when we recommend the S election. And as a lawyer, I love when people come to me and say, we're an S corp. And I say, no, you're not. What do you mean we're not? I think you're an LLC.
Yep.
You tax as an S corp, but you're not an S corp. If you set up as an S corp, you better have a really good reason why.
Yeah.
Because they're very restrictive organizations in and of themselves. There are reasons. They're large, closely held companies, those types of things. S corp can make sense. Mm. Beyond that, set up as an LLC. So that's a long-winded way, again, of answering your question.
Yeah.
If you find yourself providing 1099 work regularly, get an LLC. Have it all flow through that LLC. You can take some tax write-offs. You can get some benefits from that. But the main thing for a small LLC, it's the protection. It's the separation of you from any potential liability. When you breach a contract, they don't get to come after your personal assets.
Your house,
It's
your
typically
car.
going to be limited to the assets of that LLC.
Yeah, absolutely. And I think we become blind to our assets so much. I think particularly the younger you are, typically the less assets you usually have. You're not so worried about it.
For sure.
But I was in the same spot at one point where it was like, okay, we're doing this. We're making money, and I'm just a 1099 right now, but I'm not an LLC. And we had to go and consult a few lawyers. Ultimately, we ended up finding you guys. And the price ranges out there for setting up an LLC, lawyers are getting paid for their time. There are some outrageous bill fees out there for setting up LLCs. Yeah. What should students look out for if they're just...
So, things to be cautious about. And there is I'm trying to remember, what's the one? You can get online, they'll form your LLC for free.
LegalZoom.
LegalZoom, it's not free, they charge a small fee, but they're gonna then come on as your statutory agent. And your statutory agent, they're gonna charge you a couple $100s a year, okay? There was another one, I can't remember the name of it, but they only charge like $25 to file it, but then they charge X amount for this and X amount for that, and it's an annual subscription of like $175. Oof. And these guys had been with this company for 3 years, and they'd paid in about $1,800. And what they had done in those 3 years is they had filed an LLC, they'd made a couple of changes, and they had been their statutory agent. I said, well, if you came to me and paid my full price, you would have paid me about $1,500 for the same thing, and you would have had a relationship with a lawyer, okay? A lot
not
of
a
those,
website.
Yes, nothing. Not a, you get to build a relationship with a lawyer. That's very, very important. If you're gonna work and you're gonna go out and work in the professional world, just like working with a graphic designer or like working with an accountant, make sure you're working with somebody who you enjoy. Make sure you're working with somebody who you can work with. But all the way back to that question, there are places where you can set an LLC up, start as $300 to $500. We do about $1,000 for a flat fee, but we're going to get your LLC, we're going to get your EIN, we're going to give you a basic operating agreement. You're going to have everything you need to kind of get out and get going. Yeah. And you're going to start building a relationship with somebody who's going to be there to help you in the future. Yeah. If somebody's charging you $2,500, $5,000, I've literally heard of companies that charge like $5,000. You get this super cute book, and they gave them this like stamp with like their company seal.
One of our first offers.
It was one of those like big, like, and I'm looking at it like, well, I mean, that's neat, I guess. Yeah. And if you want all that cool stuff, the LLC is kind of like a car. Yeah. Okay, think of it this way: you can spend $500 and you can get a car, and it will break down. You know it will, but when is the question? Yeah. You can buy a Ferrari for $250,000, yeah. But I don't know. Yeah. Most people that are starting the LLC, you want the, I'm trying to think, what's the relevant?
Toyota Corolla.
You want the Toyota Corolla.
Yeah.
Exactly.
There you go.
Want the Honda Civic.
Awesome.
You're going to pay a little bit of money for it, but you know it's going to be reliable. It's going to treat you right for a long time.
Every time I come into your office from now on, I'm going to say, how you doing, Toyota?
How you doing, Toyota? Wow. I mean,
hey, I drive a Toyota all day.
Yeah.
So,
I'm a Hyundai guy.
Yeah, well, there you go. Can't beat the Japanese-made cars, right?
Good stuff.
We touched on this a little bit, but what do our students need to know about using AI-generated content in their work?
Just be cautious. Like I said, there's going to be, as AI becomes more and more prolific throughout this industry, and please understand, it will.
Yeah.
There is no, you're not going to get rid of AI. It is not going anywhere. It is only going to become more and more entrenched in the work that you're doing.
Yes.
So you have to figure out how to appropriately adopt it, but that's the question. Again, I go back to this conference I was at. I heard AI guardrails is what they called it. Okay, so what do we determine? What does that mean? Well, it means utilizing AI to get your foundation, get your platform built with human interaction to make sure that it's right.
Yeah.
So how do we interface with that in the art world? I think it's a fantastic way. Again, when you're in that brainstorming, when you're in that work back and forth with a client, and the client says, hey, go back, new business comes to you and they're looking for a brand, and you say, well, tell me a little bit about your business. And you drop into ChatGPT and you say, hey, I need some design thoughts on a business. This is where they're going to be working. This is their target market. Here's some things they're interested in. Here's some colors they like. And it'll spit back a world of, and then you can start interfacing with it and asking it questions. Well, hey, I like this, but tell me da-da-da-da-da. And before you know it, you've used technology to take your thoughts, your client's thoughts, organize them very, very quickly, and give you some additional potential relevant information. And did you consider this? Did you consider this? Yep. Now you can take that and turn it into a finished product.
Yeah.
If you take that as your finished product, I think that's foolish.
Use AI to argue with you and generate new information.
Yeah, case testing.
Yeah.
You know, did this work? Does this not work? And you can ask AI to go out. Hey, here's my basic design. Is this going to be potentially an issue with patent infringement, IP infringement, anywhere else? And it'll look.
Yeah.
And it can look faster than you can.
Yeah.
So you use it for processes that can be automated. Use it for potential client interactions. Don't let ChatGPT be you.
Yeah.
The client didn't hire AI, it hired you.
Yep.
But you utilizing a tool to organize and really kind of interface and get your thoughts in a form where you can then take it across the finish line, that makes eminently good sense. And it's going to be a point where, again, what you're selling is your art, but it's also your time. Yeah. And if you can do a product, I was having conversations, I was driving here with another entity that is their legal tech group, and I said, man, if I could find a way to offer the work that I do in half the time.
Wouldn't you take it?
Yeah. Well, of course I would. And I would pass some of that savings on to my clients. I would love to be able to offer my products at half the price. I firmly believe, and it's one of the reasons we started this company, that everybody deserves to be financially independent. Everybody deserves to be wealthy. And in order for me to do that, I'm part of the problem. I have to drop my fees. I have to in certain areas. And how do I do that? I rely on technology. I rely on, but it's not the. It's a long way of getting.
Blindly rely on it.
Correct. It's a long way of getting around to the point that it cannot be the product.
Yeah.
It can help facilitate generation of the product more efficiently, more effectively, and frankly, get you to a better product. But you're the artist.
Very nice. Well said. And last question.
Yeah.
I think this may be the most important question. In the professional world, could you walk us through the tiers of trouble that you could potentially get yourself into as a creative professional?
First, don't lose sleep over potential liability in the work that you're doing. You're an artist. You're giving them a product, a creative product. It's unlikely. Again, if you're a brain surgeon, yeah, that's tricky. Oh, nicked a blood vessel, and sorry, grandma's dead. My bad.
Yep.
That's different than, oh, you don't like this version? My bad. Let's
try again.
Let's try again, right? So don't overthink that question.
Yeah.
Probably the most likely way that these business owners in an art field are going to get themselves into trouble is to overpromise and underdeliver. You set a timetable that's not realistic. You bring on more clients than you can meet time frame demands. That's probably where you failed to deliver the product in the way that you said you would.
Yeah.
Okay. that will create liability for you. And we talked a little bit at the beginning about trying to limit some of that liability contractually, trying to limit the amount. But again, you miss contract 1, you miss contract 2, what's happening? They're going onto your Google business profile, they're slamming you, doesn't meet deadlines,
reviews.
doesn't, and I will tell you this, you'll serve 100 clients, 99 of them will be happy, 1 will be angry, you'll get 2 reviews.
Yep.
1 angry one and 1 happy one. And the rest of the world says, these guys are 50-50. I can't deal with that.
Yeah.
So just remember that. And there's another advice to you. Put a few more happy reviews out there, okay? Let's make the world a better place and start telling people when we're happy with someone's service.
Yeah. It's easy to sit behind the screen and...
We always feel like we're doing some sort of consumer protection when we tell somebody about the bad experience we had, but we forget that we're not driving them to the right kinds of people when we fail to make a review for somebody who took good care of us.
Absolutely.
But that, and again, I wax philosophical a little bit there. So back to what might get you in trouble. I really think the major one is going to be you with your clients missing deadlines. 2, copying work, stealing work, intellectual property infringement. Those types of things can be very, very costly, and depending on who you took that work from, can raise or lower the exposure and costs that you could potentially receive. If you're going to be going to clients, if you build a big studio, you have them come into your office again, make sure you have the proper insurance, the proper entity formation. We talked about that.
Someone trips over a cord.
Exactly. Yeah, they walk into a studio setting, they trip, they walk into your office, they're injured there. Those are really simple insurances to have in place. If you're going to be a freelance and you're going to drive to clients' homes, make sure you talk to your auto insurer and say, hey, I use my car about 15% for business. Do I need to modify my policy? And that's why, again, the number 2 relationship I tell people to build after their lawyer, and again, maybe that's self-serving number 1. I'm right, number 1. There we go. If I had the big one hands, I'd be waving them. But you need to explain and talk to your attorney, talk to your insurance provider about how you provide your business so that they can give you recommendations on the appropriate coverage. And then again, really just get out there, kill it, do the best you can to provide a good product at a fair price, and I believe most people will be successful if they'll do that.
Amen. I think we've done a successful job at fear-mongering a little bit, but I think that your comment about don't lose sleep over it. Maybe lose a little sleep if you're in litigation, but
hopefully you don't have to get there.
I think for the most part, that's kind of the last stage.
Yeah.
There are gateways before that don't ignore those warning signs.
You will rarely end up in court without knowing you're headed to court.
Yeah.
Take good care of your clients, provide good customer service, own your mistakes, have the proper insurance, the proper coverage, so that if it does end up in court, it's like, hey, look, I'm sorry we're there, but we got you covered, that kind of thing. Yeah. And just be open-minded. Make business decisions. When somebody's angry about something and they want $500 back, don't yell, I'll see you in court.
Right.
If it's reasonable, give them $500. Let them walk away and don't do business with them again. Yeah. Just using good common sense and having somebody, a good attorney to bounce that back and forth with, is a great idea.
I love it. Ted, you've been a great attorney, both to us at the studio as well as today. Thank you for being here. I really appreciate it. That is it for our questions today. So thank you very much. And go ahead and follow up with your lab. If you have any questions, feel free to reach out on Slack.